I'm not doing a lot for your blood pressure at the moment because yet more post office scandal. What I'm doing here is sort of, a lot of people are covering the sort of broader picture very well, better than I am doing. But I've been delving a little bit deeper into what was actually going on sort of behind the scenes. And one thing that I found out was that in the Bates trial, there was what we call a recusal application. That is where the post office asked the judge to stand down. Now, what's unusual about this is, first of all, this was made in the last week of the trial. Normally with a recusal application, you would identify the issue early and it'd be one of the first things you deal with. Because what's the test for recusal? There's two limbs to it, or two elements. Firstly, that the judge is actually biased. And I've done a video on recusal applications. That's something we very rarely say, the judge is actually biased. Although, it does occasionally get done. But the more normal test is that there is an appearance of bias. And what you say there is, well, judge, we know you're not actually biased. However, an outside objective observer, knowing all the facts of the matter, might think that there is a risk of bias. I mean, that could be something like, in a company dispute, a judge owns shares in the company. Now, if you just have a few BT shares and it's just a row about a phone bill, that probably wouldn't be an issue. But how did this arise? Well, because of the complexity of this litigation, the cases were split. There were so many people involved, but there were so many issues that just for convenience, they split the hearings. And some of them were hearings on sort of single issues. I mean, this is quite common. You quite often have split trials. Say, for instance, it's a personal injury case. There'll be, first of all, is the defendant liable for the injuries? And there'll be, well, how much, what should the damages be? What's the level of the injuries? So sometimes you'll just say, well, let's just have a trial on liability first, because if you find we're not liable, we don't need to go to all the expense of having a trial and calling expert witnesses on medical evidence or something like that. I mean, that's a very common way of doing it. So what they'd done in this particular case is they'd had a trial just on some technical issues about how the Horizon system worked. The judgment for that case came out while they were in the middle of the actual Bates case. And it was the same judge. But what happened is, in the preliminary issues, the post office witnesses had just been caught out blatantly lying. And, the post office themselves had been caught out really breaking rules on disclosure, things like that. I mean, it was quite extraordinary. And, if there's an interest in this, I will go into it in more depth. But like I say, have your blood pressure medicine waiting. So what was very unusual about this is they didn't even tell counsel that they'd made this application. I mean, they actually left it quite late because the judgment came out several weeks before the Bates trial. So obviously somebody had looked at it and gone, this is not looking good for us. So poor old counsel had to turn up at the hearing and say, because they were in the middle of cross-examining somebody. So the judge said, okay, we'll just halt everything now, but you're going to have to get a shift on. Because they said, oh, well, this needs to be adjourned so we can do it properly. And he was saying, well, no, you've just sprung this and you've had plenty of time to think about it, so we're doing it tomorrow. And they had to argue and say, well, Judge, you've actually now found that a load of witnesses who are witnesses in this case are liars. Therefore, you will have prejudged, because they're giving evidence in this and we're arguing that they're telling the truth about this. And you've already ruled that, no, they've already lied about all this. And that is very unusual because, it's not uncommon for people to say, well, Judge, you ruled against me in either a previous case or a previous hearing in this case. That's never been a good reason for getting somebody excused. And to be honest, the judge had, he very gave it short shrift. But the actual recusal application, they threw the kitchen sink in. They put in 30 cases on recusal, and the judge said it's a one-line test. Everybody knows about it. It's a case called Porter and Magill, which is, like I say, would the outside, objective, reasonable person think there was a problem here? And the fact that a judge had assessed somebody's evidence, which is a judge's job, might say, well, that's not a problem. I mean, judgments are always written in fairly neutral language, but you could really see that the judge was going, "Oi, on your bikes here," because effectively they were just asking, saying, can we have a judge, we'd like a retrial in front of a judge who doesn't know how terrible we are. A few other things came out. The actual claimants in this case, they before they were allowed to bring these cases, they had to pay £3.9 million on account against the Post Office's costs, which again just seems, rather harsh. So had it not been for the goodwill of people sort of raising money and lending money for this, they wouldn't have even got a chance. But here's another thing that came out. In trials, you have what we call disclosure, where you have, each side can ask for documents from the other side. And the claimants asked for a report. They said, we would like a report about the Horizon system. And this poor old barrister had actually stood up there and said, no, this, we don't have this report. We don't have this report, so we can't get it. It's in the hands of third parties. And they would only hand it over if you were to make an order, ordering that. And the judge said, well, that's not really appropriate. I can't force third parties, effectively, who aren't involved in this litigation, to hand over things. However, the barrister then found out that was untrue. The Post Office did have the report. They'd had it for over a year. So they had just lied. Certainly they had lied to the barrister. He was acting on instructions from the solicitors, and it's probably, that they'd lied to the solicitors as well. I'm not bad-mouthing the solicitors here. At some stage I will go on about some of the conduct of the lawyers in this case. I'm very reluctant to criticise other lawyers, but some people have really crossed a line. So what's that poor barrister to do? Talk about embarrassment. He actually had to write a letter to the judge and just said, dear judge, a bit of an issue here. I've stood up in open court and said this, which has clearly misled the court. Obviously I didn't do it deliberately. And the judge totally accepted, because this is a decent guy, that he hadn't done it deliberately. But it just goes to show, and what's very interesting is, courts take disclosure obligations very seriously. I'm a bit surprised that on the back of that, because your conduct in the litigation can be a factor, and one sanction a judge can do for failing to abide by your disclosure obligations, especially when you've effectively lied about having something, I'm surprised he didn't actually strike out the defence. But there you go. The more we dig into this, just the worse it gets. I can see why they probably not want to mention this in a television programme. It's all highly technical and boring. But yeah, as I've been reading into this, there's all sorts of terrible things. So, it'll be very interesting to see what the outcome of this is. But there you go. As always, if you found that vaguely useful, vaguely interesting, wildly infuriating, please consider clicking, liking, sharing, subscribing, all that sort of nonsense.